I assume you've all had a chance to revitalize yourself with some caffeine, and we're in the home stretch, and in the interest of keeping the program on track, I'd like to invite our next speaker, Ian Wallach, to speak. He's a partner at Rich Rothstein. I always think of Ian as being the guy there. He's been doing accounting and that kind of stuff in the personal injury area, and specifically on the AB side of things for, I believe, longer than I've been a lawyer. So Ian practices in the area of personal injury and other damage type claims, quantifying economic loss, doing forensic and investigative accounting. If you haven't already heard Ian speak somewhere, you probably have just become a lawyer, or a paralegal, or an OT, or you have crawled out from under a rock, because Ian does this probably at least one speech somewhere every week. He's been involved in many cases that have actually gone to trial, and his reports and his opinions are very well respected and highly regarded. He has oodles of court experience and is always found to be very persuasive, and I guess a good thing with accountant is his math's always right. So with no further ado, Ian will be speaking with us on quantifying the IRB and on non-earner benefits.
Okay, so I'm going to try and discuss and elaborate on some of the more important income replacement benefit issues. We do primarily work on behalf of plaintiffs in the case of income replacement benefits. And I just have one comment that the easiest way to avoid insurance fraud is not to pay any benefits. Insurance fraud occurs when someone knowingly makes a dishonest claim. It also occurs when an insurance company fails to pay a legitimate claim. And we've all had stories of people who have been very hard done by. Some of the more important issues and changes which occurred with the new regulations which occurred on September the 1st, 2010 are as follows. One, there is a new definition of long-term disability benefits. Long-term, as a consequence, long-term disability benefits which are purchased by self-employed persons are no longer deductible as collateral benefits. That's a very important change. Let me go on and deal with another couple of issues. There's a case out there called Cromwell versus Liberty Mutual. What happened in the case of Cromwell versus Liberty Mutual, Diane Cromwell was receiving income replacement benefits at the rate of $300 per week. She subsequently went and settled her long-term disability benefits for a lump sum. She then went back to the insurance company and said, because I've settled my long-term disability benefits for a lump sum, I'm no longer receiving periodic benefits, and you need to start paying me income replacement benefits at $400 per week. The court agreed with her because she was no longer receiving income replacement benefits, because she was no longer receiving long-term disability benefits on a periodic basis. There was no further deduction. And the reason for that was there is no provision in the legislation to deal with lump sum long-term disability benefits, and the judge was obviously not going to create that legislation, which has not yet been created. The other important decision is a case called Merle-Slater. In this case, Merle-Slater was approved for CPP disability benefits approximately 2 years after her initial application, and she was approved on a retroactive basis. The insurer sought to deduct the CPP disability benefits which she received on a retroactive basis from her future income replacement benefits. and the court said that collateral benefits can only be deducted on a prospective basis. This is a very important decision because a lot of insurers are not applying it. When we've been asked to critique reports commissioned for the insurance company, and we've asked the question, why have you not applied the Slater decision? Responses which we've got back are that that decision is too complicated for us to understand. They're able to interpret every other decision, and they're able to interpret the legislation in minutiae, but when it comes to that decision, there it's too complicated. Other excuses which we have received: excuses provided include the fact that this is a complicated legal issue or an underwriting issue for the insurance company to determine, or are outside of those accountants' expertise. One accountant actually wrote back to us and told us that he had been asked to ignore this decision by the insurer. Exactly why he was asked to ignore that decision was not specified. I presume it was because of the fact that her income replacement benefit entitlement would have increased. Another change in the new legislation is that it's only post-accident earned income from employment which is deductible when you compute income replacement benefits. Let me give you an example. Let's say you have a real estate agent who's injured in a motor vehicle accident, and he's now lying comatose in Sunnybrook Hospital. Before his motor vehicle accident, he closed a home sale and received and earned a commission of $6,000. While he's lying in Sunnybrook Hospital comatose, he receives this commission of $6,000. Is this post-accident earned income? The new legislation makes it very clear that it's not post-accident earned income. It is pre-accident earned income received post-accident, which is not deductible in determining income replacement benefits. Let's give another example. Let's say that a person is an owner of a business, and that business continues after the accident. Is the post-accident income earned by the business automatically post-accident income from employment? The answer is no. The court decisions say that you have to do something in order to have post-accident earned income. So the mere continuation of a business, if the person is no longer actively involved, is no longer post-accident earned income. This is again another amendment which is typically only applied by insurance companies on request or as a result of the implementation of proceedings. In its decision in Heath versus Economical, the Court of Appeal made it perfectly clear that in order to have earned income, you have to do something to earn that income. The fact that you're unable to work after the accident means that any income that you may receive is not earned income from employment. Another issue is a person employed or self-employed? Fiscal decisions when it comes to employed versus self-employed are all over the map. Rather than go to Fisco, you might as well spin a coin. Legocky versus Allianz was a decision of a court where the judge held that even though Mr. Legocky had identified himself as being self-employed on his income tax returns, for income replacement benefits, he was in fact an employee. The situation was as follows. Mr. Legocki provided care services, provided attendant care services to an Alzheimer's patient, to a single Alzheimer's patient. He was paid by the patient's son, and he decided to report the income that he received, which was typically paid in the form of cash, as self-employment income as opposed to employment income on his tax return. He freely admitted that the reason for reporting it as self-employment income on his tax return was to claim deductions which were not available to employees. In her decision, the judge decided that substance takes priority over form. She held that, in fact, irrespective of his self-identification as a self-employed individual on his tax return, Mr. Legocki was, in fact, an employee. The big difference being that Mr. Legocki was able to base his income replacement benefits on the 4 weeks prior to the accident as opposed to the last 52 weeks or the last fiscal year. So the mere fact that somebody identifies themselves as self-employed on their tax return does not automatically make them self-employed for IRB purposes. Martin versus TD General Insurance is another recent case. What happened there was Melissa Martin performed some babysitting services for a neighbor on an occasional basis for which she received payments of, I believe it was $30 per day. She did not work on a regular basis. In this instance, the judge considered this payment not as employment income, but to be in the nature of an honorarium. In his decision, he wrote, "I find that the plaintiff's connection and commitment to the workforce at the time of the accident was sporadic, and that she was primarily a homemaker. Her testimony at trial that she did not regard the babysitting as a job and accordingly did not report these monies on her income tax return as income was credible. She was doing a favor for a friend and was simply reimbursed for her expenses." Another change in the legislation is that the new legislation allows an insured to recover up to $2,500 towards the cost of a report detailing his or her income replacement benefits. This $2,500 allowance applies to both employed and self-employed situations. No prior insurer approval is required, and it applies to both situations where the insurer has hired its own firm of litigation accountants and situations where they have failed to do the calculations. It also applies to accidents before September the 1st of 2010. It is only subject to a reasonable test. So subject to a reasonable test, this $2,500 can be claimed if we review the insurer calculations which have been done by the insurer and we agree with them. We can still claim the $2,500, and it also applies in situations where we agree that no additional benefits are payable. Because an insurance company is on the hook for $2,500, we have tried very hard to promote the idea of joint assignments. In my opinion, and particularly joint assignments where entitlement is not in dispute. Remember that the insurance company is already on the hook for $2,500. Why not use these funds to avoid conflict and expedite the claim resolution process? It is not a problem for us to address the report both to the insurance company as well as the insured. We are not advocates for either party. Let me tell you a story. This $2,500 looks like easy money, but it comes with an aggravation premium. We received a pile of documents from a law firm, and the law firm said to us, is it possible to calculate this individual's income replacement benefits on a reasonable basis. Attached, please find all the documents which we have sent to an accounting firm called H&A. We did the calculations and we concluded yes. Although it wasn't possible to compute the individual's income replacement benefits with certainty and with precision to the penny, it certainly was possible to calculate the income replacement benefits on a reasonable basis. And that's the criteria, a reasonable basis. Consequently, we did our report, we sent it to TD Meloche Monex, together with our bill for $2,500. We recently got a letter back from TD Meloche Monex to say that they discussed the matter with H&A, Forensic Accounting, that they did not agree that it was possible to calculate income replacement benefits on a reasonable basis without the additional information requested, and as a consequence, they were not going to pay our $2,500 bill, and H&A was in agreement therewith. So it comes with, this $2,500 does come with an aggravation factor. It was exactly those kinds of situations which the legislation was designed to avoid. Another important provision, although the new SABs purportedly reduced the interest factor based on when the expense arose, there are two decisions at Fisco which say that the interest rate of 2% per month compounded monthly depends on the date of the accident, not the date on which the expense was incurred. There are two decisions. One is called Federico and the other one is called Subramanian. There are two Fisco decisions which say that if your accident was before September the 1st of 2010, the old rate of interest of 2% per month compounded monthly still continues to apply, irrespective of when that expense was incurred. Just a couple of comments on the role of accountants. Accountants have expertise in making reasonable allowances, and we do this, for example, when we prepare financial statements and we estimate bad debts, we estimate capital cost allowances, also known as depreciation. However, when it comes to income replacement benefits, particularly those paid to the self-employed persons, often nothing gets paid until the accountants are able to determine with certainty and to the penny exactly how much the self-employed individual should be receiving. Based on the hundreds of cases which we've done, calculating a self-employed individual's income replacement benefits with precision as opposed to a reasonable basis and calculating it to the penny is often not possible. You're required to make estimates. Business people are typically not expert accountants and typically do not maintain records specifically to facilitate income replacement benefit claims. People, as a general rule, and your legitimate claimants do not plan for a motor vehicle accident. Thus, when you base the individual's income on the 52 weeks pre-accident, you can't do it with certainty. Estimates are going to be required. And that is, we see it time and time and time again, used as an excuse for the complete denial of benefits. Our experience is that not every self-employment situation is deserving of a full forensic investigation. Not every tax return, particularly tax returns filed prior to the date of an accident, are deserving of a full audit. As a general rule, and it goes without saying, in the case of tax returns filed prior to the date of a motor vehicle accident, self-employed persons are more likely, rather than less likely, to underreport rather than overreport their income. Accountants have expertise in making reasonable estimates, and the need for precision should not be an excuse for the complete denial of benefits. Self-employed claimants typically need and should be entitled to their benefits on a prompt basis, subject, of course, to an insurance company's reasonable due diligence. In summary, the objective of professional accountants hired by an insurer is not claim minimization. Irrespective of the party that hired them, professional accountants have an obligation to calculate benefit entitlements promptly and without unnecessary claimant demands and on a reasonable and even-handed basis. I just want to give one final comment. As a strategic matter and as plaintiff counsel, you should always consider writing to the insurer asking them to have their forensic accountants compute income replacement benefits on a specified basis. For example, ask them to calculate income replacement benefits that on the basis that an insured has no post-accident income, given that as we previously explained, given that the interpretation of post-accident earned income is a legal matter which may well be outside the accountant's expertise. A refusal to compute benefits even on a hypothetical basis can be very useful in demonstrating bias on the part of the accountants hired by the insurer. I thank you for listening. Unfortunately, there's no time for questions at the moment, but there will be time later on if anyone.
Two speakers, so we can save questions for them at that point. Ian's one of the few accountants out there that I know that can actually turn the math and the case law and mix it all together and make some sense of the IRBs and whatnot. So I encourage you, if you have some questions, to speak to him. Our next speaker is David Levy. He is a partner of mine at Howie, Saxon Henry. David is, excuse me, he's probably the lawyer in our firm who has, at this point in time, the most trial experience and arbitration experience of everybody in the office. I can never find him because he's either getting ready for a trial or an arbitration, or he's off to Fisco or some courthouse somewhere in Ontario doing a trial. He's a member of basically all the associations that we have in Ontario for lawyers, trial lawyers, as well as the medical, legal, and those kinds of associations. And he's been a lecturer at many places in the province, let alone at the various different organizations who have these lectures. And he has spoken at length as a guest lecturer at the Osgoode Hall Law School on the area of motor vehicle law and accident benefits. So I know that David's going to have some very interesting things to tell us to help lawyers and paralegals understand when a claim should be passed on to a lawyer. And this part of the program also has some points for ethics and professionalism for those people in the room who are interested in needing to fill out those Law Society forms. David?
Thanks, Mike. They fixed the podium here somewhat. I've been working with Jim and Mike and Adam for like 15 years now, and as I watched some of the earlier speakers struggle, I thought, for once, finally, my being so much shorter than the rest of them is going to come in handy. But now they fixed it. I have the ethics and professionalism topic for today, and I've sort of been given 3 little mini topics to go through, and I'll try to get through them in the time that we have. The first one is about assessing the value of a claim, and Brad took us through what I'll call the science part of assessing a claim, and obviously I'm not going to go through that again. Brad did a nice job with it, although we're going to have a talk about your opinion on ties a little later. But I want to talk about the art portion of assessing a claim, because there's 2 sides to it. There's the science of assessing a claim, figuring out the damages, doing the math and quantifying them, and then there's the art portion of what is a claim actually worth, particularly what is it worth for settlement purposes. And in order to do that, you have to start with, well, what is the maximum value of the case? And then you have to be sensible and somewhat self-critical about the case and what it's really about. What are its strengths and what are its weaknesses? What appropriate discount factor needs to be applied to the various benefits or damages that you're seeking? And in order to do that, you have to ask yourself some fair and sometimes tough questions. How credible is your own client? How truthful have they been throughout the case? How believable is their story from start to finish? What sort of risk tolerance does your client? Can your client weather? Does your client have the stomach for a trial? Does your client have the financial resources for a trial, or potentially to survive a trial or arbitration that could potentially go badly and have cost consequences be awarded? What type of immediate financial needs does your client have? Are they in a position to wait it out for a year or two as necessary? Or are they really struggling for funds at the moment such that that can therefore color their settlement thoughts? These are all questions that need to be asked, and the reality is there are no fixed formulas. There's no supercomputer that you can just plug all this into and tell you what the right settlement number is. These decisions are always going to be made in the context of a client's life and the other factors that clients have going on, the ones that I mentioned earlier and other ones as well. So it's really quite critical before you start negotiating anything with an insurer that you get a sense of where your client stands on all of these factors. Whether you are going to be more or less aggressive in your negotiations, whether you're going to try to accelerate the process or sit back and wait until the insurer comes to you, is going to be dictated, at least to some extent, by where your client sits in this. And you can't effectively advocate for your client, you can't really do well by your client if you just sort of jump into it without knowing where your client stands on all of these things. So even if you've gotten past the discovery, let's say, or you've gotten into arbitration proceedings, and you think it might be time, the case might be ripe for settlement discussions on as far as the being able to quantify the benefits or the damages, remember that ultimately there's a person, there's a client behind all of this, and we have to know what he or she really wants, needs, and feels before you can go ahead and start sensibly the negotiations, knowing the strengths and weaknesses of your case and your client's position, and most importantly, where you really want to end up. The second topic that I have has to deal with treatment providers and fraudulent claims. And ultimately, this is about trying to keep your clients in the hands of reputable people who know what they are doing, who do good work, and of course who are respected by everybody who works in the industry, including the insurers. And there's an old saying that always comes to mind here about you being judged by the company that you keep. And I think that saying is very applicable when we talk about the treatment providers that our clients are treated with. Now, we've all heard the insurance industry's claims of fraud. Fraud is rampant and it's everywhere, and it's this massive virus that infests our entire system. And maybe I'm naive. Some people would surely agree with that. I think that these claims are wildly overblown. I think that they are manipulated and extorted for political purposes and for the never-ending grind that the insurance industry has on the government to try to get them to reduce benefits. But despite the fact that I am convinced of that point, there's no question that there is some fraud out there in our system. It exists. We're all tarred with that brush to some extent, sadly. Some of our clients who are perfectly genuine, our treatment providers who are perfectly genuine, are hurt by the fact that there is some fraud out there. And fraud comes in many forms. We've all heard about staged accidents, bogus dummy treatment plans that are filed without even actually having patients, doctored attendance sheets, phony billings, treatment plans that are just filed in cycles so that mediations can be filed for and this sort of war of attrition is fought. I know Eric Grossman's going to talk to us in a bit. He probably has seen half a dozen other forms of fraud or pseudo-fraud, and I'm sure there are others as well. And make no mistake, the insurers are quite right to be upset about the fact that this sort of thing goes on. It costs money for them to resist these, to deal with them, to process them. It takes resources, it takes time and energy away from applying monies and benefits to the people who are genuinely injured and actually need it. And make no mistake as well, the insurers keep close tabs not only on all of us, being the lawyers and paralegals, but also on the treatment providers out there. They have lists, this was referred to earlier by one of the other speakers, lists of the people who they feel are less than genuine, and there's really nothing worse than being associated with a facility that the insurance company thinks is a fraud. No matter what your client says, they're not going to trust your client. And quite frankly, to some extent, as the representative, as counsel, they're probably not going to trust you either. And it's even worse if the insurance company believes that you have any type of business interest or financial interest with this facility that they believe or they consider to be fraudulent. And the bottom line is that there are many reputable facilities out there, tons of them. I mean, our market is somewhat heavily saturated with them, as we know. There are tons of good people out there. Use them. Do not allow yourself, do not allow your clients to be associated in what is a very, very negative way with places that even have reputations of being fraudulent. And that's a big word, fraudulent. I'm not just talking about places where they think the bill's a little high, the number of sessions is a little rich. Places that are considered to be fraudulent, you simply have to keep yourself, your business, your clients away from them. There are many situations as well that certainly don't amount to fraud, but that some people, the insurers I suppose, might consider to be other levels of abuse, less serious ones no doubt, but other levels of abuse. And quite frankly, you want to try to stay away from that as well. And there are a few ways in which you can do that. Treatment plans are supposed to be signed by the clients. Make sure that the clients are actually signing them and that they know what they're signing. Make sure the treatment plan is completed before the client signs it. Make sure that the client understands what they're signing for. Don't be afraid to look critically at what is being proposed. Does it seem sensible to you? You know, you don't have to be a health practitioner in order to know that some treatment suggestions simply don't pass the smell test. And don't be afraid to withdraw a treatment plan if it seems inappropriate. You know, we always get so frustrated when an insurer acts in a way that we feel is totally intransigent. No matter how rational and sensible our argument is about why the treatment's needed, they said no the first time and they just, no matter what, they're not going to change their minds just because ego and stubbornness get in the way. Well, don't do that yourself. If something seems like circumstances have changed or maybe it just wasn't a great idea, don't be afraid to withdraw something. The insurer will appreciate it and you can go in a different direction. I see my time is already running a little bit short. I want to move on to the last topic, which is when a claim should be passed on to counsel for handling. This is one I suppose that is directed primarily at paralegals, though most of what I will say here applies to lawyers as well. There are some statutory requirements. I think they were covered a little bit earlier. Superior court claims, catastrophic claims, and of course the one that always amuses me, the has or appears to have a catastrophic claim. I always thought if I got referred a case like this and had to take it to arbitration, I would call the paralegal as a witness and you know, just have to say to the arbitrator, I was going to handle the case myself, but it looked catastrophic to me, so I had to pass it on. The rest of it, though, besides for the statutory restrictions, everything that I say, I believe, applies to lawyers as much as it does to paralegals. And the situations in which you want or need to pass a claim on or get a lawyer involved essentially involve asking yourself the following questions. Do I have the experience or the expertise to handle the claim? Are there issues that arise here that I just haven't seen or experienced before? Do I have the financial resources? Do I have the manpower resources to be able to see this thing through? Do I provide a credible threat to take the case to trial or arbitration if the insurer will not settle the thing in a sensible fashion? If one or more of these questions are answered yes, you do need to strongly consider, getting counsel involved. You do right by your client in doing so, and quite frankly, you do right by yourself. You enhance your reputation as someone who's not simply looking to settle something quickly and make a fast buck, but as someone who is looking out for their clients and trying to make sure that you get them the best possible result. You send the right message to insurers for future claims down the road, and we all hope to have long careers, that you're the kind of person who's not going to simply be pushed around and not the kind of person that they can dismiss, but someone who has to be taken seriously, not only for this case and for all others. And don't kid yourself. The same way that we talk about adjusters and insurers, they talk about us. Lawyers, paralegals alike, they talk about us. Your reputation is important. It's important to your practice, and it's important to your clients. Now, when you talk about referring files out to another lawyer or getting another lawyer involved. It's easy to say these things and it's easy to talk about doing the right thing by your client, but there's always an elephant in the room, and it's something that I think it's important to address. And that, of course, is the business side of things, and the fees and fee splitting and referral fees and the business interests that we all have in our cases. And it's natural for the referring lawyer or paralegal to think, well, you know, come on, these cases all settle eventually, so I'll just hang on for long enough and the insurer will pay, and I get to keep the whole thing for myself. And unfortunately, it just doesn't always work out that way. It might sometimes, but a lot of times it won't, and the longer you hang on, if you've answered yes to those questions I asked earlier, the larger the chance of you getting yourselves into trouble. So it's not just for the lawyer to whom you're referring that this is a good business issue. I mean, let's not kid ourselves. The lawyers to whom these cases are being referred, and this is a big part of what we do, is acting as counsel. This is part of our business. But I want to explain why it's good business for you as the referring paralegals or lawyers to do so as well. Number one, you're going to level the playing field. You're going to bring in people who have the resources that we talked about earlier. And of course, by leveling the playing field, you're going to essentially be able to leverage the file for a far greater result. And a greater result, of course, given the way that we all typically charge, means that there are going to be larger fees to be split. In some instances, the difference can be so great that the fee that you might recover by referring the file might be as large as it would have been had you kept it on your own. And even if that isn't true, there's always the opportunity cost associated with referring a case out. The time that you would have had to spend, and it's presumably significant on larger and complex cases, the time that you would have had to spend working on that case can be spent with other files, bringing in other business, working on other business, and so you're actually working on files simultaneously by doing the work that you're actually doing while having other work actually done for you. And then at the end of those cases, fees are split and referral fees are paid. And as I'm sure you're all aware, the referral fee legislation for paralegals is the same as for lawyers. And our treatment of referral fees for paralegals is exactly as it is for lawyers as well. And in the end, what we see then is a value-added situation in which it really becomes a win-win. And a win-win-win because let's not forget about the client who has won as well by the value that's been brought to the table. And there's one last point that I want to mention, and it's something that I like to call file protection. And the reality in complex cases, in cases involving significant injury, is that those people are seen by a myriad of health professionals and treatment providers and doctors and assessors, and of course, you know, the bigger the case, the more friends come out of the woodwork. And there's almost no doubt in my mind that in the life of every claim, at some point, somebody says, and by the way, who's your representative again? And of course you tell them, and everybody's got an opinion on everything. And if it's someone who isn't, if the representative is someone who isn't known to the person asking the question, there is a very real possibility that the next thing out of that person's mouth is going to be, you know, I don't know who that is. And so I'm just going to assume that they're no good, even though there's no rational basis to do that. And let me send you over here to talk to this guy, because I heard of them, and I know that they're good. And this really isn't fair, because there's no basis for this. You could have done nothing wrong. In fact, you may have done everything totally by the letter and 100% right from the minute you ever first met the client. But people's opinions being what they are, and optics being what they are, you will run the risk of that file then being taken away by someone who just takes it over. And the financial reality of that is pretty harsh, because you end up now with a very, you have an account that you can render, and it never comes close to anything that you might have expected you were going to earn on the case. And it doesn't come close to what you would have earned on the case had you involved counsel that perhaps is a little bit better known, been around for a little bit while longer, whose name is more recognized in the industry. And so by involving counsel earlier in the process, you protect the file in that respect. and you protect your own interests in the file, because that's the sort of thing, and I hope I don't sound immodest by saying that, a firm like ours isn't going to have that happen to it. Absent somebody who's deliberately trying to poach a file, a firm like ours simply isn't going to have that happen to them. And so not only is it good for the client, it's also good for you. You're protecting your financial interest in the case and avoiding that really kind of worst case business scenario in which you lose the file when you haven't done a single thing wrong at all. I see my time is up. Thank you for listening. Have a good day.
And of course, the other elephant in the room is when it goes off to the lawyer because the AB case was settled, and the lawyer says, what happened with your accident benefits file? And the client says, well, I got $5,000. And the lawyer loses his or her mind because that obviously wasn't enough money, and then says, well, we probably need to sue the paralegal. And while the paralegal is insured, if you get too many claims, it's going to put you out of business. So it's important to be mindful that, you know, somewhere down the road, someone could be looking over your shoulder, so to speak, and it's just bad math. Our next group is a panel, but it's going to be mostly Mr. Howie and Mr. Grossman speaking, with Ian and Louis available for questions or comments when it comes to accounting or the medical end. For those of you who don't know Eric Grossman, you have to get out more. He speaks more than Ian, if I can say that, and he is everywhere. He's the founding partner of Zarek Taylor Grossman Hanrahan. He's recognized as a certified specialist in civil litigation by the Law Society and has been recognized by Lexpert as a repeatedly recommended expert in personal injury law. He only practices defense work and has a thriving and extensive accident benefits practice. He has spoken at all of the usual suspects, including the Ontario trial lawyers, where he's asked to leave the room after he speaks. He's the past chair of the accident benefits section of the Canadian Defence Lawyers, and he has consulted with the FISCO on numerous issues from time to time. That just goes to show how highly regarded he is. And I do believe...
They don't listen to me at FISCO.
Yeah. And I do believe that, well, remains to be seen. And you are the publisher of annotated service on accident benefits as well. So obviously the man to hear from the defense side. And his counterpoint is Jim Howie, who is the founding partner of Howie, Sachs and Henry. He's a former director of the Advocate Society and the Medical Legal Society and the Toronto Lawyers Association. He is a member of the Ontario Trial Lawyers Association and many other organizations, including BIST, the Brain Injury Association of Toronto, Canadian Institute, Lexpert Insight, and other programs he's frequently lectured at. He has lectured at Osgoode Hall on insurance law for the last 5 years, has been qualified to give expert evidence in court on personal injury matters. For 14 years, he's been listed in the Canadian Legal Directory as a leading practitioner in personal injury law. He is on National Post list of best lawyers in Canada since they started it many years ago. And under his and Adam's leadership, Howie, Sachs and Henry was recently named one of the top 5 personal injury law firms in Canada. So both Eric and Jim have done this dog and pony show, if I can say that, and it's always very entertaining. If you have any questions, you may want to just step up to the microphone while they're talking. Is that okay?
Sure. I'm going to start with 2 points that, in response to David. Firstly, from the defense perspective, let me tell you that the last point David made is entirely correct in respect of referrals out from paralegals and lawyers to more known lawyers. I can tell you that what we instruct our people to do in our office, and what we've been doing since as long as I can recall, in assessing a case, we have to look at a number of different variables. One of them is obviously who the claimant is, what their background is, what their age is, what their injuries are. Those are obviously the most significant variables. But next on the list, in my view, is who their lawyer is. Because if they're with lawyer A or with lawyer Z, the outcome will be greatly different. And we factor that into our analysis. And if there's a change, getting a change of lawyers on a file is as significant an event as getting clinical notes and records that show a different picture than what you expected to see. So it's a very significant event, and I agree with David on that. The other thing that I want to dispel, David, the notion of for David, is the fraud out there. I am counsel on one of the major pieces of fraud litigation out there involving one insurer, and I've done some extrapolation in math without Ian's assistance, so it may not be right, where I've taken a look at the market share of that insurer, and I've taken a look at the fraud that it can prove in respect of its top 3 clinics as they rank them, and looked at how many other clinics there would be in terms of volume, and taken that math over the course of about an 18-month period and extrapolated it against the industry, and I've come up with a figure of $15 billion. And maybe I'm wrong, maybe it's not 15 billion, but it's as likely to be 20 as it is to be 10. The stuff out there will boggle your mind. Hiring chiropractors to do brain injury assessments. That's happening. It's bad. Luckily, David and the folks at this firm don't see very much of it. Unfortunately, I see a lot of it. It's bad. He's right. Stay away from these bad apples.
So there's a number of questions that I'm posing to the panel. Eric, breaking news in cases affecting accident benefit claims, and what effect might they have, in that area?
Well, at 12 noon today, the Court of Appeal will be releasing its decision in Pistori and Aviva. Of course, it's only 11:45, so no one really should know what the outcome of that decision is for another 15 minutes. I have the decision. It was released to the parties at 10:30. Does anyone want to know what it says? It's a 32-page decision written by Justice Kathy Feldman and concurred upon by the other 2, so there was no dissent. In it, she said that the divisional court was in error in applying its test on judicial review, that they owed deference to the director's delegate on a reasonableness standard, and that was done in error by the divisional court. The court then went about analyzing the director's delegate's decision in some significant detail and came to the conclusion that the decision was reasonable, and therefore the divisional court decision was overturned and the director's delegate decision was restored. Any or a marked impairment is enough. I'm the only one who can boo. Is that the story? I can tell you.
Actually, Eric secretly cheers.
What I expect from this, I suspect that this was the last straw or the last shoe to drop for the government to now act on the panel's recommendation to make changes to the catastrophic definition. I expect that the insurance industry will now heap greater pressure upon the government to make those changes on an expedited basis.
Yeah, my only comment would be that much as we love the minority government in Ontario, being a minority government, they may have difficulty from the other parties as to whether or not they'll be effective in passing legislation that makes major changes. As always with changes that may come, we all watch, wait, and figure out how to work under the new system. So Eric's correct that it's likely the government will at least start to work down that road It seems as though the last 10 years or so, every time they started to work down that road ends up being temporally very long, 3, 4, 5 years. And often, just as they're about to pounce and make major legislative changes, along comes an election, they table the legislation, and they're back to square one following the next election. If you like the thought of them restricting the catastrophic definition generally, then I think you should absolutely support the Liberal government. If you don't, you might want to think about supporting somebody else when the next election comes around. And I'm not telling you Eric's wrong. He's probably right that they'll get a lot of pressure from the insurers to make changes. They already took a couple of stabs at this, so they're likely going to try to do something.
It's my best inclination that the only reason why the changes haven't been implemented to date is because OTLA has made very clear to the Liberals that support for them might be fleeting if they do. And that, I suspect, will be reinforced in the coming days and weeks. Whether the Liberals can withstand that type of political pressure as against what will now become more heated pressure on the other side, only time will tell.
All right. There's been a large backlog, obviously, we know, at Fisco. Have there been any steps taken to help in that area? And, how's that affected MIG cases?
There have been lots of steps taken. Firstly, I was counsel on the matters that were taken on appeal. McCorney and Clark and Eunice, and there's a fourth one that escapes me momentarily. They went to the Court of Appeal July 19th. That decision is still pending. Pistori was heard in January. It was released in September. I think if we use that approach, we should be waiting another 4 or 5 months for this decision. I frankly don't think it should take that long. I also was counsel on appeal in the Leone case that went on appeal to Fisco. That didn't go so well for the defense. I would be surprised if the Court of Appeal was to do anything different than what was done in the appeal in Leone, so I don't hold a great deal of hope, although I do hold some hope in respect of the Eunice case, which had different facts. So again, the government Fisco seems to be waiting on that decision to do anything in terms of legislative changes. I expect that they will implement some legislative changes. In the meantime, however, they have this outside vendor, ADR Chambers, is involved. They are going to be taking 2,000 cases a month from the backlog in mediation and hiring outside people to do those mediations, and starting in October, 500 arbitrations a month additionally. So it's going to really tax both plaintiff and defense side in terms of getting manpower to make themselves available for pre-hearings and for mediations and for arbitration dates. Luckily, ADR Chambers is not compelled to have these events occur in a timely way. They are only obliged to offer dates in a timely way, and if the parties are unavailable to accommodate those early dates, they aren't obliged to push that. But if one side is ready to do a mediation next week and the other side isn't ready for 2 months, then they have to go back to Fisco for direction on whether that can be pushed. Same for pre-hearings and hearings. It's going to help cure the backlog, I suspect, within a year, even if they don't make any changes to the legislation. But the effect of it has been profound since the changes to the regulations in 2010, because it's shocking that we have no arbitral authorities on what is an incurred expense, no arbitral authorities on what a MIG is, and yet we're all working with this for 2+ years now, and we're working in the dark. Insurers are really reluctant to water down what they understand those definitions to be without any authority for that proposition. And so the loggerheads continue. There are more cases in dispute than need be, because once the definitions do get interpreted by an arbitrator, I suspect a lot of the fights will disappear.
Jim, we know about the 50,000 coverage on the med rehab. So let's take a situation where somebody's 6 or 9 months out, post-accident, they've used up their 50,000, but they obviously still need treatment. It's too early for them to be considered catastrophic. Anything you can do?
Well, we run into that situation a lot, as I'm sure many people in the room do. There are a variety of tactics or things that you can try to do that may assist in this area. First of all, a lot of times you'll have 1, 2, 3, 4 different treaters, 5 different people coming in to provide treatment, whether they're physio or OT, massage therapy people, attendant care people. You need me up there? Sorry, Dave, thanks.
She's trying to hear you.
What? Thank you. Sorry. So one of the things that you can do clearly is ask the treatment people if, particularly if they're covered by OHIP, whether or not they'll switch from being paid the exorbitant insurance rates back to OHIP rates to continue providing the treatment to the person involved, to your client. Believe it or not, many will. Oftentimes in the various treatment industries, they view, probably correctly, certain insurance cases as a bit of a cash cow, where they're actually getting paid much better than they might under OHIP rates to provide services on an ongoing basis to somebody who really needs it. And a lot of these treatment providers get quite invested, as I guess we all do, when you deal with an individual on an ongoing basis. You develop a personal relationship with the person, you like them, you become invested in how they're doing. And for a treatment provider who's often, personally invested in helping somebody get better, it's tough, I think, to say, oh, no more money? I guess I'm just going to back away. Sorry, good luck, hope you work out. A lot of those treatment providers, I think, will happily move on to an OHIP-funded payment system as an alternative to, gee, I'm sorry, the 50 grand's gone. A lot of times, particularly where we have a tort case going at the same time as an accident benefits file, sometimes our accident benefits files are looked after by paralegals, for example, and we're handling the tort end. You can approach us, and we will approach first the client and say, look, are you prepared, client, to sign an agreement that you will pay the provider at the end of the tort case out of your tort proceeds? And that can be organized quite easily. And if the provider agrees to delay their payment or defer their payment until the tort case gets finished, 6, 12, 18, 24, 36 months down the road, treatment continues, you in effect run a bill. Also, the way our legislation works, those treatment costs can be added in as a separate out-of-pocket expense on the tort part of the case. So that even if the client doesn't end up being considered catastrophic, you in effect are running those bills up and they're the responsibility of the tort defendant. You could arrange a loan for the client through one of the professional loan agencies, like Bridgepoint or settlement lenders. Companies like that are in the business of providing treatment funding loans. The biggest drawback there, of course, is the interest rate. Charging interest rates anywhere from 18 to 25% a year, compounded, plus some usually administration fee tacked on for actually signing up the loan agreement. We encourage our clients to use that basically as a last resort. It's not something you want to do except in a situation where treatment is really desperately needed. You've exhausted all other possible avenues, and there's no other place to go. One other thing that I don't think enough lawyers or paralegals think about often enough is one other option, which is to ask the insurer through either their claims representative or their counsel if they have one, would they please consider making an advance payment repayable at the end of the tort case to continue treatment. I know I've had discussions of this type with Eric and other what I would call sane or sensible defense counsel, and they actually think it's probably not a bad idea. If we're in a case where you can't tell if a victim is catastrophic or not, they might be, they might not be. The accident happened 9 months ago. They're not clearly catastrophic yet, so we're all a little bit in the dark. We're waiting for the 2-year point to do reassessments, figure out if they're cat. It's often in the insurer's interest to continue to help that person get better so that when they get to the 2-year point, they're not catastrophic. When they get to the 2-year point, maybe they've started back to work instead of still being on the income replacement benefit train. And that's a big advantage to insurers, in my view, and often they'll continue to pay treatment. The downfall of some plaintiffs' lawyers or paralegals who represent claimants, I think, is that they think, well, why do I want my victim to get better? I'd prefer they get worse. I want a better chance that they're going to be catastrophic. I want a better chance that their case is bigger. I don't view that as an appropriate answer. I think the opposite. I think we want our victims to get as well as they possibly can, to recover as much as possible. If they fit into this category of the system, we'll get them the compensation they're entitled to. If they fit into this category, we'll get them the compensation they're entitled to. But for God's sakes, when they've got the rest of their life ahead of them, let's help them get as well as possible. There is a fifth possibility.
Do you want to respond to number 4 before you go to 5?
Beg.
Beg. I was just going to say that I often advocate to my clients to do exactly what Jim has suggested, because it insulates that insurer from a bad faith claim if indeed the person is subsequently found catastrophic. You'd be shocked and amazed at how few plaintiff's counsel will actually say when I offer, or where the insurer offers to continue funding on the condition that it be repaid out of the tort proceeds if they're found not catastrophic. You'll be shocked and amazed at how few plaintiffs actually take that offer up, because there's a risk and a concern that, well, what if they're not found catastrophic? That continued funding is going to come out of the tort, and they're going to end up with virtually nothing at the end of the day. And so they say, all right, thanks for your offer, we're not going to pursue that. And yet we're ahead of the game even more so because we're not funding it, and we're off the hook for bad faith subsequently because we've offered it.
You got a last point, Jim?
So Eric, we all have headaches with the word incurred. I understand you have a few comments you'd like to make about that, and in respect of some recent cases, the definition, jurors' interpretation of it and whatnot.
There's only one case. It's called Henry and Gore Mutual. And it's a judge's decision. In it, bad facts make bad law, and this was a dumb case for the insurer to pursue, in my opinion. This was a case involving a catastrophically injured boy who had $6,000 a month of attendant care needs, whose mom worked pre-accident earning $2,100 a month. And the insurer said, yes, you've suffered an economic loss by quitting your job to look after your boy. Yes, there's no doubt that your boy has significant needs, but the measure of your economic loss is $2,100 a month, and that's what we're going to pay you, as opposed to the $6,000 a month, which the Form 1 says the boy is entitled to. And the judge said that was kind of silly, and if they've suffered any economic loss, they're entitled to the full measure of the damages, being the $6,000 a month. That decision's under appeal. I would be surprised if it was overturned. I have been making the view known to my clients that that is the only sensible interpretation, and I suspect it will continue to be the only sensible interpretation going forward. The question becomes, what is the threshold, the real threshold for what is an economic loss? I've been quoted more than once as saying the person who wears out an extra pair of socks a month because they're climbing up and down the stairs 8 times a day to look after their bedridden dependent, that person needs to buy a pair of socks for $5 a month additional. That is, by definition, an economic loss. Is that going to be enough to get the $6,000 a month that is on the Form 1? I have a more difficult time with that being found to be the economic loss, but from a technical perspective, it may be. And so, if the person's not in the workforce, if the person's driving someone to an appointment once a week and burning gas that they're paying for, is that an economic loss? Those are the tougher questions. We have no answers yet because of the backlog.
I'll just make one comment on that. Eric and I are basically in agreement on this issue that the economic, we have been since we started talking about this issue some years ago, that the economic loss doesn't really have to be that dramatic probably to get over the hurdle. Incurred means incurred. If you have an economic loss, it doesn't matter if it's $10. It's an economic loss. The tougher issue for us lately has been that a few insurers have adopted some very bizarre positions on these issues. We have one case where a woman spouse looking after her injured mate has had to alter her work hours, gone from working 35 hours a week to 20 hours a week, basically spending every available hour except the 20 hours when she's working, providing attendant care to her spouse. What the insurer said was, well, your economic loss here is the loss of your 15 hours at your minimum wage. So that works out to $812 a month. We'll pay you $812 because that's your economic loss. I said that's a convoluted interpretation. You owe $6,000. In fact, technically you really owe $8,000, but it's limited to $6,000. So you'll have to pay the $6,000. The insurer says, no, we'll offer you $812. So we're fighting that case.
That's an easier case. What of the person, in my view, that's an easier case.
He means that we should win.
Yeah. What of the person who was going to school pre-accident? The caregiver, the person who's now giving the care was going to school pre-accident, who was intending to upgrade so as to get, who was not working so as to get a good job down the road, and that person has now stopped going to school, and therefore the economic loss is a potential future economic loss because they were going to become a doctor, whereas now they're not going to be anything.
We have that case at least once, and I know we have it once with one of your insurers, where a young woman who was 18 or 19 was in her first year of university, or just between actually high school and starting university, and the insurer said, well, no economic loss. We were able to show that she put a deposit down in her first year, which is lost. And so we said, there's the economic loss. For whatever reason, the insurer's fighting that.
Yeah, those are tougher cases. I mean, the tuition helps, but if there isn't any money out of pocket, it's a real challenge, I think.
So we tacked on 10 minutes, so we've got another 5 minutes. The last question will be for Jim, and it's more directed at the topic, which is the paralegals. We see many files where the paralegal's been handling the ABs for 6 months, 12 months, whatever, or they've settled the accident benefit matter, and then the clients come in to us just however, not referred by the paralegal, and they want to talk about a tort case. What is the biggest mistake you see that happens on the AB side with the paralegals handling these files?
That's an interesting question with this crowd. I would say it's a two-part thing, and it's really, first of all, failure on most of the paralegals to get some help, and secondly, an unwillingness to say no. I'm going to talk about the unwillingness to say no part first. Lawyers and paralegals are honestly not much different. We spend some time in our office teaching our younger lawyers in our office the technique of saying no. You need to know that when you're representing a claimant and somebody comes to you as a negotiation and offers you 50% of what the case is worth, and they say, that's the last nickel, not another nickel, that's what we're offering. And you know in your heart that the case is worth twice as much money, just say no. No's easy. Yes is easier, but say no. There's often a risk on all of us to say, well, I want to make a fee here, I'd like to get some money now, I got the rent due in a month, and I want to make sure I get the fee out of this case so I can pay my rent, and I need to make sure the secretary gets paid, and I got that overdue bill for whatever, so I'll say yes and tell my client to take 50 cents on the dollar, and that's fine. That's clearly sacrificing the client's best interest for starters. It actually sacrifices your own interests as well. The insurer that you are dealing with, I almost guarantee you, will be the insurer you're dealing with in 6 months on another case, if not sooner. And they're going to remember that you took 50 cents on the dollar. Not only are they going to remember, but they're going to tell all of their friend adjusters and everybody else in their office that you took 50 cents on the dollar on the case. And that is going to undermine your ability to negotiate every single file. Reputation, your reputation, is actually your most significant asset that you have. And taking much less money or less money than you should on a settlement offer is going to only hurt that reputation. There's an old saying somewhere that Eric probably remembers better than me, that reputations take a long time to build up and only a few seconds to screw them. So keep that in mind. Going back to the first point, failure to get some help, which kind of ties in with this. We often see cases where the paralegals have dealt, in my view, perfectly appropriately with dealing with all the paperwork, handling everything the way they should, running the case through, making sure that the insurer pays on time, squeezing some interest out of them when they're late. And at some point, 12 months, 18 months later, they get the AB settled on a full and final, and they'll sometimes send the tort case to us at that point. Say, okay, now I don't have to worry the lawyer's going to take over the whole case. I'll send it to a lawyer I trust, whether it's me or us or Howie Saxon Henry or even somebody else. But they'll make that choice and say, okay, go see them. And we get the file, and we have to, by nature, look back at the accident benefits file. And sometimes we see the case has been settled for 50 cents on the dollar. And sometimes we see somebody who's catastrophic where the paralegal chose to settle the case for $100,000 for the whatever was left on the $50,000 or $100,000 on the net rehab, cashed out the future IRBs for some number, and honestly didn't get enough. I don't think it hurts any paralegal to phone a lawyer that they know or trust, even someone that they are starting a relationship with or have a relationship with, and say, I got this case. I'm not sure exactly what it's worth. I'd like you to give me a quick opinion. Can we meet and have a cup of coffee, and I'll give you the facts? And you can just tell me roughly, what should I be looking for? Are there issues I might be overlooking? The insurer tells me this. I'm not sure they're right. In my office, I doubt there's a lawyer in my office who wouldn't say, sure, let's meet for coffee, and I'm buying. No fee. Happy to talk for 15, 20 minutes, talk about the essentials of the case, and give you a quick opinion. The worst thing that happens is you go back to your office knowing you're doing the right thing, or knowing that you shouldn't be settling. Either way, I don't think it hurts you. And that I think is probably a critical error that I see in what's being done in some of the paralegals. Probably nobody here, but the others who aren't here.
Well, the only thing I'd say in response is that your definition of 50 cents in a dollar may be different than mine.
So that brings our program to an end. Thank you, everyone, for coming. We've taken 10 minutes of your time extra. Appreciate you taking the time to come, as well as our speakers. And for Eric, Louis, and Ian, I have a little token of our appreciation, as well as St. Mike's Hospital. Just to let you know that your attendance today, all of the proceeds are being donated to St. Mike's, and so there will be a check in the neighborhood of something around $11,000 or $12,000, depending on the attendance, going to the hospital. So thank you very much on behalf of the firm and the hospital. There has been no time for questions. I do apologize, but most of the people are still here, and they're more than open to give you an email address, talk to you, give you a business card. And you can always just email our office, or Maria, Ahmed, if you need emails or contact information or more information about how to get your Law Society points. So again, thank you, everyone. Hopefully this program was beneficial in giving you some insight into how to better represent your clients. And thank you for attending.